are live now. Hi, everyone. I am Angela Kretschmann, lawyer and a researcher at Federal University of Curitiba and PUCRS, and I'm here to introduce you the panel number 8 with the topic Data Protection in Information Society. Due to COVID regulations, we could not again attend the public in person, so we are live streaming all the event. We will also be making the video of this event available, so do not worry if there are some connective problems. For those who are logging online, we know the technology does not always work the way we want it to, but the full panel is being recorded. First, I will give you some tips on how the panel will work. Our presentations will be held in English, and we will open right after for questions. We will dedicate the remaining time to conduct the debates and answering any questions from the audience. So, we know we have quite a few distinguished guests online following us on live stream, so please, who have questions, make a note you may have, and we ask you to use the chat to submit questions. And we will be nice, it will be very nice if it came already in English, it will facilitate our debate, will save time and misinterpretations. To get the certificate, just register the CODAIB event, filling in all data. Certificates will be issued after the event and will be accessible online. So on behalf of JEDI and the event organization, I'd like to say thanks to our audience and to our guests today. And I would like to extend a special word of welcome to our guests. In fact, a warm welcome to Thomas Hoeren, who will talk about protection of trade secrets in Europe, an alternative for the protection of non-personal data. And then Professor Ingo Wolfgang Sarlet, who will speak with the topic fundamental right to personal data protection in the Brazilian constitutional order. I will give you now some briefly resume of our guests. They don't like that very much, but it's a rule for us and our audience want. Professor Thomas generously received me in Münster at least in 2011, 12, 15. There I was able to experience the daily life of a researcher. I could make copies of books without fear. I could ride a bicycle. The ITM lends a bicycle to each researchers, in addition to offer the library key, so you can enter at any time of night or day to study. And that was something very surprising for me, and it resulted in a great incentive for research. A feeling of belonging, and that visitors are really very welcome, for which I will always be very grateful. So Münster is my second home, I miss it a lot. Now a few words about Professor Thomas. He's one of the legal advisors of the European Commission at the Legal Advisor Board on Information Technology. He's also a board member of the Research Center for Information Law of the University of St. Gallen, Switzerland. Since June 2000, he's working as a domain name panelist for the WIPO. In 2005, he became a member of EXPERT, a committee for copyright and publishing law at the German Union for Intellectual Property Protection. From 2012 to 2014, he was a dean of the Faculty of Law at the University of Münster. Since 1997, Professor Hoeren is based at the Institute of Information, Telecommunications and Media Law at the Westphalian University in Münster, Germany. He has been a Superior Court judge, and over the last 20 years, he has been involved in research on intellectual property law and computer law. Since 1997, he is director of the Institute for Information, Telecommunications and Media Law, and he is told several times, really several times, that he is not a fan of traditional view of IP law. He created then the Institute for Information Society, where he is also a part of it, integrant and strong researcher of the ITE. And he's also a committed photographer that usually is not online. And now about Professor Ingo Sarlet. He's a doctor and postdoctor in law from the University of Munich, Germany. He was a judge since a long time, and now he is retired of TJRS. Now he is a lawyer and legal consultant, keeping your academic activities, especially as full professor and coordinator of the postgraduate program in law at PUCRS. He was a visiting researcher at the Max Planck Institute for Social Law and Social Policy Munich in 2001, 2003, 2019, and 2020, at the Georgetown Law Center 2004, Harvard Law School 2008, Stellenbosch Institute for Advanced Studies Africa do Sul 2011, Max Planck Institute on Foreign and International Private Law Hamburg 2017, 18, and 2020. He was a visiting professor of several universities, such as Pablo Olavide, Seville, 2007, at Faculty of Law of the Catholic University of Portugal, Lisbon, for the Erasmus Mundus program of the European Union, 2009, at the Faculty of Law of the University of Lisbon, 2012 and 13, at the Master of European Constitutional Law in Granada, and was also a visiting professor of the Faculty of Law of the University of Hamburg, 2020. He integrates the Faculty of Supervisors of the postdoctoral program at the University Las Palmas, Canary Islands, Spain. Professor Ingo is a longtime friend, and I currently conduct research with him at PUC involving intellectual property. Both are terribly busy, making it nearly impossible to bring them together for a panel. But here we are, and we won't waste time. So let's start with Professor Thomas with the topic Protection of Trade Secrets in Europe, an alternative for the protection of non-personal data. So over to you, Professor Hoeren.
So great. Thank you very much for inviting me. I have chosen not a topic of data protection law, but I want to show you that there is an alternative system of protecting data, and that is secrecy law. That is becoming more and more important in Europe as the European Commission has established a new directive on secrecy laws and harmonized each national secrecy law. But there are a lot of striking questions. I will skip to show you my stupid PowerPoint presentations. I hate PowerPoint, but I want to show you a little bit what I want to do. The starting point is the new EU directive. It's called the Directive of the EU of 2016 of the Parliament and Council on the protection of undisclosed know-how and business information against their unlawful acquisition, use, and disclosure. That is, in the meantime, implemented in almost every European member state. You can compare it to a piece of national legislation which you have in Brazil, because Brazil has a totally different but comparable legislation made in May 1996. What is the aim of the protection? The protection is made for data, but not personal data, non-personal data. These data are protected if, and then now I'm coming to the two most important requirement of a secret. It is secret in the sense that it is not generally known or made accessible to a person. That is very easy. It should be a secret. So the second element, however, causes a lot of problems in European cases. Data is only protected if it has been subject to reasonable steps under the circumstances by the person lawfully in control of the person, of the information to keep it secret. Reasonable steps. You have really to protect the data so that you can claim this is my data. And what is a reasonable step? That's very, I will come to that within a minute. In this moment, all European IP lawyers are thinking, wow, now we have a new intellectual property right. That's a birth situation. A new star is born. The IP law has a new star called secrecy law. I don't believe anything these strange IP lawyers said, because secrecy has nothing to do with IP law. That was expressly stated by the European Commission in the directive. They said, sorry, we have nothing to do with IP law. We are a system of unfair competition or labor law. The problem is, however, we have a system of unfair competition and labor law, but the new directive has far more rights attributed to this secrecy system. So you have a lot of rights for damages, for injunctions. You can prohibit the publication. You can say stop it, destroy all the data. So the number of rights attributed to secrecy is immense. That is, of course, in favor of the IP solution. These guys who wanted to say it's IP law, they say, look at the directive. It has made so many new rights that we can only explain secrecy by a reference to IP law. But the European Commission has, as explicitly stated, is not IP law. That is against the system. The consequences of these two approaches, is IP law or is it unfair competition or labor law, can be shown if you look to the law of conflicts of laws. Because when you ask yourself which secrecy law is applicable on a national basis, you have to find a rule to determine, is it French law or is it German law or whatever. If you say this secrecy laws, that is IP law, you would use the principle of territoriality. That means every state which might be affected by the use of a secret information can apply his or her national law. That seems to me totally exaggerated. I am a fan of the unfair trade or labor law solution, and in unfair trade, we have the principle of the direction of intended purpose. So if you're using the information, the judge has to ask, what is the intended purpose for using this secret data? That's the solution under unfair trade law, and the labor law guys who say secrecy is only a problem in labor relationships. They would ask for the mother country of the employee. So you see that all three models have different solutions in conflict of laws. That's not only the only problem. Another problem is the question of secrecy and reasonable steps. what is a reasonable step to protect certain data? That's the typical answer of a judge to say it depends on the circumstances. But if you look to the cases from France or from Germany, you see what is definitely needed is a LOI, COA, or NDA. That means a letter of intent, a confidentiality agreement, or a non-disclosure agreement. You have to have agreement in order to protect your secret data. That is extremely important because it's new in Europe. In Europe, before the directive, we said we recommend a non-disclosure agreement, but now it's necessary to have one and to prove one. But now we have the typical arrogant US lawyers who said, so if you need an NDA, we will say everything which was produced during a labor relationship is secret. They are making a definition in an NDA saying everything ever told, ever produced is secret. They're saying everything in life is secret. That sounds strange. It's possible under American law to do that, but the Court of Appeal of Düsseldorf, my court, has clearly stated 2 months ago that this is not possible in Europe. You have to explain in detail what you think should be secret. And you cannot say everything is secret. So you have to define it, but then you have an additional problem. If you're defining the secret information, you have to really say what is secret. So you have to explain the secret information. That's against the nature of secrets. You don't want that to tell anybody what is really the basis of secrecy in your relationship. But this problem cannot be solved. You need to define very clearly what is the subject of an NDA, and you have to clearly state what is protected under secrecy law. But there's another problem. The Court of Appeal of Stuttgart has made another famous decision 3 months ago and said it's not enough to have an NDA, and then non-disclosure agreement. You have to have objective tools for protecting secret information. That might be a password, a good password, not password test or laugh 1, 2, 3. You have to have a good password, and you need a TOM. What is a TOM? Is not a short word of my first name. It's a technical and organizational measurement under the Data Protection Directive. Now I'm coming to data protection, because in European data protection law, you need a certain paper where you explain who is accessing information, for what purpose, how long. The paper is called TOM, Technical Organizational Measures, and that is needed not only in data protection law, but also in secrecy law. That's very important to understand. You have to define who gets access for what purpose to secret information. So, and what is then striking? If you have such a system of bundling a lot of rights together on the basis of secrecy, you need exemptions. So you have to define in which circumstances can you use secrets for free. Very important, in Article 5 of the directive, the directive says, is no infringement if you are revealing a misconduct, wrongdoing, or illegal activity, provided that the respondent acted for the purpose of protecting the general public interest. That's the first phrase in European law for whistleblowing. The protection of whistleblowers is, but the definition of whistleblower in this Article 5 is very, very strange. You have to act for the purpose of protecting the general public interest. In Germany, we had people who are saying this company is always violating tax law. And they go into the tax authorities and they said, I have a CD with all the data. They are not doing that for general public interest, but for the purpose of getting money from the state. So the state pays a lot of money to get a CD where you can see who is violating tax law. Is this whistleblower exempt from the secrecy directive or not? Nobody knows. Nobody knows. Take for instance misconduct, wrongdoing, or illegal activity. Can you say this company has not made a legal mistake, but they have violated ethical rules? And is it allowed to open secrets for proof of ethical wrongdoing? Then this regulation is so broad in an exemption that you cannot have a clear system. So that's the one thing. And another exemption is regulated in Article 3. That is totally unknown in Europe. That's an invention of the Americans. They said free is you can use any secret data for the observation, study, disassembly, or testing of a product that has been made available to the public. That means, as a competitor, you're allowed to buy a product for a competing company. You can destroy everything and see how the system works internally, and then you can build up your own product. That was totally forbidden under old law. Now it's allowed. Nobody can sue against somebody doing reverse engineering. In Europe, we have the problem, is it then allowed to say, we will exclude reverse engineering in contract? Can you make a contract between two competing companies saying you agree not to use reverse engineering tools? That's an open question, very unclear, and that's need to be decided by the courts. At the end, I tried, and of course, to make at least one sentence in Portuguese, Brazilian. I cannot speak Brazilian, which sounds to me to the most beautiful language on earth. I'm sorry for that. Angela can speak perfectly German. Ingo, of course, is an expert in German, but I cannot speak Brazilian. But I invite you to contact me if you have any questions. If you are interested in the PowerPoint slides, I will send everything to you, and contact my homepage. You will find podcasts, ebooks, which are for free, I'm a fan of free publishing everything on the internet. So that would be great to see you again, at least virtually. And that finishes my talk, and I say, obrigado, obrigado, obrigado.
Muito obrigada. Oops. Thank you, Professor Thomas. Thank you for your kindly words and for your great presentations. You always have some surprises for us. It's amazing to have you here today. And I know that we don't have so much time. I already have some questions, but we need to go on. So I ask to Professor Ingo, please. Now the word and the video and audience are yours.
Okay, thank you, Angela. My first words, of course, are of gratitude. I thank the promoters and organizers of this 15th CODIPE in the name of Professors Markus Wachowicz. I hope to pronounce the name correctly. And Angela Kretschmann, my dear friend and colleague. I also would like to greet my panel colleague, Professor Dr. Thomas Hoeren from Germany. It's an honor and pleasure to share this panel with him, and also to know about these new trends, the secrecy law, and of course you were absolutely right in saying that we have huge differences between our legal orders, and it's also something we must really advance and fastly also in Brazil. Before starting my short presentation, I have two remarks. The first one, please apologize my English, which is not my first foreign language, but I'll do my best to be understood. And second, as widely known, I'm not an expert in international property rights and in secrecy laws, but just a mere constitutional law professor. That's why I'm not even touching aspect related to intellectual property, to not doing anything wrong. That's not for sure that I will do everything right in relation to data protection, but at least I'm closer to my field. And my intent is indeed very simple, modest, is to present some general comments on the fundamental right to data protection, the Brazilian constitutional order, its foundations, content dimensions, and limits. I will do my best to do it in the time. I think I've heard 20 to 30 minutes. It should be 20. I will, of course, shorten. I was prepared for 30 minutes, but I can shorten as well. Of course, we know that at the constitutional level, this is my focus. The fundamental right is the focus. We have, of course, a very slow evolution in terms of the recognition of this right as a fundamental right, at least in the constitutional text level, because we have two ways to recognize this right: as a non-written or implicit constitutional right. That's the way Germany, so far I know, has undertaken since the early 80s, although not speaking directly from right to personal data protection, but self-determination, informational self-determination right, which is not necessarily the same, as you know. But of course, we have a parallel evolution at the legislative level, at the regulatory level, and of course at the constitutional level. And only a few constitutions have really contemplated this right early. One of them, I think it's already the first one, is the Constitution of Portugal, which included this right in her first version, 1.0 version from 1976, though having reformed this article 3 times later, but only including things. But it's in fact a first and even detailed regulation of the right, although not mentioned directly data protection, but really also involving data protection in the 70s. Now, Spain has some indirect right to data protection even in 1978, but even not today, a lot of countries do not have included this right in this constitutional text. In Brazil, our way in this sense was a little bit different. To a certain extent, we were relatively in advance, innovative in 1988, because we had, in fact, we have in our constitution since 1988 the secrecy, the inviolability of data communication, which is also not the same, and we have the habeas data action with the status of a fundamental right in our constitution. It's not, of course, the right to data protection, but an important instrument to implement this right even through the judiciary. But even having these two really important aspects regulated in our constitution, the recognition of a right to data protection as an autonomous right itself really take a long time. And it was only last year, in May 2020, that our federal Supreme Court, Supreme Court Federal, recognized in a very remarkable and important leading case an unwritten implicit right to data protection, deducing this right as usual, even due to the German influence and the European influence, but as well as a plea from our literature for years, from the human dignity principle, the general personality right, the self-information, the informational self-determination right, also an implicit right among us, privacy rights, etc. Maybe because of this decision and the entering into force finally and completely of our data protection, general data protection act this year, of course the fully in force only this year, the Congress, National Congress, approved finally a constitutional amendment introducing a specific right to personal data protection in our constitutional rights catalog. And of course, we can ask, that's the first thing I want to discuss, is if this inclusion in our constitution changes something really after this decision from our Supreme Court. Does it really make a difference to have this right enshrined in the constitution, or decisions from a Supreme Court or a constitutional court like Germany or others recognizing such a right? Maybe not, maybe yes. It will depend on our Supreme Court and how, of course, this right will be interpreted from now on. I think one factor is important. It's really different when a Congress, a national Congress, with almost unanimously, in a very complex and rigorous procedure, really say this is now a fundamental right. The basis of democratic legitimacy is, of course, much stronger than a decision of 11 justices, even being, in fact, not disputed or this decision in this sense. The other advantage is that the right to data protection is now a fundamental right in both a substantial and formal sense, and is granted as such, because, of course, to be or not to be a fundamental right makes a difference when we know there's a fundamental right is, of course, has some prerogative in terms of constitutional protection or even normativity. And it means that also the full regime of fundamental rights will be applicable now once the direct applicability and efficacy of fundamental right norm, like we have in Article 5, Paragraph 1, that all state organs are directly bound by the right to data protection. This, of course, is not really changed in relation to the implicit recognition. But now the right to data protection, differently than in German, at least partially different, is now a substantial limit of constitutional amendment. This right cannot be removed now after this decision of our Congress. So this is, I think, in my sense, an important step. And then this last aspect I would now mention is that it makes a difference in relation to the limits and restrictions of the right to data protections, because as an implicit right, we do not have a requirement. I don't know how to translate this in English. Maybe you can help me, Angela, or someone. Reserva legal, Gesetzesvorbehalt. I would say this in Portuguese and in German, so Professor Hoeren can understand it. Reserva legal or Gesetzesvorbehalt. As an implicit right, we don't have a Reserva legal or Gesetzesvorbehalt, but the Congress included this right with Gesetzesvorbehalt or Reserva legal. And this, of course, makes some difference in terms of restrictions and the control, of course, of the constitutional legitimacy of restrictions, as we can say, can see later. Of course, we have some other advantages. And of course, these advantages are the same, in fact, if the right is implicitly or expressively recognized. A first aspect I want to underline, maybe not really well understood up to now by everyone here in Brazil at least, is that even the General Data Protection Act must be consistent with the requirements of this right. And we have indeed some aspects of our Data Protection Act that are not necessarily indisputable in terms of their constitutional consistency, like the exceptions for the consent, for instance. We have another problem, and of course, this is that can be solved, or at least the data protection right, as a fundamental right, is in this sense a kind of general framework. For this, we must harmonize diverse legislations in terms of data protection, because we have some aspects of data protection, our Access to Public Information Act from 2011. We have some aspects related to data protection in our Marco Civil da Internet Act from 2014. And of course, now in our General Data Protection Act. And these aspects are have some contradiction, even conflicts between this legislation. And of course, the constitutional framework is of course a way to establish this harmonization, solve even these conflicts in the light of the constitutional requirements, is also, in my sense, an important function of this, to a certain extent, new fundamental right in our constitution. But we have another application for this right, because we have certain domains in which we have a lack of regulation, because our General Data Protection Act is not meant to be applied in the fields of national security, public security or safety, criminal investigation and prosecution, and criminal procedure. All these fields are not covered by our General Data Protection Act. And of course, we need data protection also in these fields. But the fundamental right to data protection apply to these domains, and is of course of highly importance. If you not have the regulation, we have some drafts now pending in the Congress, but still we don't have an answer from our legislator for this. Very important fields and domains, like even secrecy laws, because of course legal persons or juridical persons are also not covered by the legislation. Of course, we can argue that we can have, even to a certain extent, include legal persons in this protection. We know that it's being discussed. But so far, up to the moment, it's not the case. So that I think it's something about the importance of the recognition of this right we should take into account from now on. We have, of course, the question: what is really an autonomous right? It is only an academic figure. For our own satisfaction to write and talk about an autonomous fundamental right to data protection, or it really has some important practical consequences. And I think we know that it has some consequences, but if I listen to people, I sometimes I really can see that it's not really clear what is an autonomous fundamental right, and hope to be now on a correct path. Please, Professor Hoeren, correct me if I'm wrong. But of course, data protection has important links and even some superpositions with other fundamental rights and principles. I just mentioned these principles and rights: human dignity, personality rights, self-determination, informational self-determination, privacy, etc. But the autonomous character means that there is a specific zone that this right has its own scope of protection, âmbito de proteção, as you can say in Portuguese, Schutzbereich, and it has his own essential core or essential content, which make a difference in several cases, situations, also in situations related to the limits and restrictions of this right, which means that in terms of his scope of protection, that right to data protection cannot be reduced to the informational self-determination, cannot be reduced to privacy, as we know, because it had also an autonomous sense. That's why, for instance, we don't have a priori, of course, a priori irrelevant data for the scope of data protection, because you know that even what we can think it's completely relevant for us, put together, combined, can form profiles, and they can be really highly invasive and threatening, can threaten really our fundamental right, not only the data protection right, but several other rights, right, the right to discrimination, and others. I will now finish, because we have, I want not to use my 30 minutes, but I think we must at least say some words about the condition of the subjective dimension of the fundamental right to data protection. That's important because we know in our constitution, differently than in Portugal, we know we have nothing saying about the content of the right, which subjective rights, which subjective positions an individual has based on this right. But of course, we have a catalog of subjective positions, which are subjective rights of the data owner, of the of course rights holder. And this is And this list is usually given by the legislator, an infraconstitutional regulatory framework, not directly, or at least not as a rule directly, in the constitutional text. And of course, this list elaborated by the legislator, it's very broad, also in the Brazilian case. We have, of course, several rights, subjective rights of the rights holders of data protection in our General Data Protection Act. I can't read it now. I have the list, but I can't read it now. I have no time for this. What I want to say that even this list, and this is another importance of a fundamental right to data protection, is not a numerus clausus. It's not an exhaustive list. New rights can be added, new subjective position can be added by the legislator, and also can be recognized as implicitly contemplated based on the fundamental rights at constitutional level. I will give an example. I know that's a controversial example, but it's indeed an example. The right to be forgotten. Let's, even forgetting the term, I know the term is not the best, right to be forgotten. You must understand it well. But let's talk about the right to the indexation from research engines at the internet. The right to the indexation is recognized, at least by some important decisions from courts, even in Germany, but it's not on the list. It's not at the list. And of course, we can talk and have reasons to sustain that we have a right to the indexation as one of the subjective positions related to data protection. At least I think we can say so. And this is why another reason why we can say welcome to this right in our constitution, to these decisions of our Supreme Court. I have organized some remarks on the limits and restrictions of this right, but I will finish here. We have some time for discussion. This is really more important. I thank you for the patience. I hope being understood, sufficient, clear with my broken English. Thank you so much.
Thank you very much, Professor Ingo. I would like to say to who are listening and watching, we need to understand that today we are very lucky to have Professor Ingo speaking here in English, because he speaks Portuguese so fast that sometimes it's really hard to understand what he's saying. And the same happens with Professor Thomas Hoeren. When he speaks in German, it's almost very, very difficult to understand. So both today needs to speak in English. How nice. Thank you very much. Well, I don't know if Professor Thomas wants to say something about, because he was mentioned by Professor Ingo.
Yeah, thank you very much for your really excellent presentation. I really appreciate that very well. Let me, you asked what is the value of writing a right to privacy or self-determination in a constitution. In Germany, you know, the courts, the constitutional courts, have always refused to force the legislator to change the constitution. So they invented the rights themselves. And what I think is interesting is the specific jurisdiction we have on telecommunications privacy. Because I like the decision of the Constitutional Court in stressing the need for telecommunication as a very dangerous place where you need to protect citizens. And I would be very eager to know how you solve that problem in Brazil.
Professor Ingo.
Okay, that's really a challenge. Okay, I thank you, Professor Hoeren, for the question. Of course, we have some difference in Brazilian law. The first one I want to mention is differently than in Germany. We do not have a media privilege in our legal and even constitutional system. I'm not sure that's correct, but it's the way the Constitution has been interpreted. We have, of course, I express several mentions, if not only one, to the freedom of communication. That's what you mean for social communication, for media, in the Constitution. Informational, the right to inform, the freedom of information and the press, and the freedom of expression, freedom of opinion. But in fact, our Supreme Court make no difference between them, and the regime applied is the same as well. The prohibition of anonymous speech is general. The private censorship of it, everything is the same. So the general rules applied are the same. Of course, related to data protection, in this context, we have some attempts to recognize the German IT Grundrecht, the German computer right. This was mentioned directly in some decisions of our Supreme Court related to email monitoring, now we have the problem discussing the problem of cryptography and the WhatsApp. So that's of course something that's going on now. But the plea for this right to protection of the confidentiality and integrity of informational systems in the sphere of even of the communication information technologies is of course being discussed and it starts to be recognized by our Supreme Court. But we are still beginning to develop this approach. We do not have a tradition in this sense, like in Germany now, but we are really starting to recognize this. But I think we have some problems with this general interpretation without really important differences between these diverse dimensions from data protection, communication, telecommunication, and so on. So that's I can say now shortly. I hope I have.
But listening to you, I have the feeling that the Brazilian constitutional courts very much look over the ocean to other countries. So,
yes.
What would you say? What is the impact of German constitutional court cases in Brazil? Are these cases carefully studied?
Yes. I think we have it's important impact, especially the I think two domains I would say: the fundamental right dogmatic and the constitutional procedural law, control of constitutionality. Here we have really a huge impact coming from Germany, from the literature and from the Federal Constitutional Court decision case law. The objective dimension, Schutzpflichten, duties of protection, Untermaßverbot, the organizatory and procedural dimension, limits and restrictions, proportionality, all this has been included, right to informational self-determination, Computergrundrecht, all this has been introduced in our literature, and it's common case law in our Supreme Court. That's usually because we have a lot of people studying in Germany, and of course these people in the literature and as professors or even in the court, like Schumann Mendes, who's Münsteraner, of course are responsible for this flow, but we know some things should be really better adapted, or not everything can be of course copied.
But let me ask you an additional question. We have a tendency in Germany that more and more civil courts are applying constitutional rights. We would say mittelbare Drittwirkung von Grundrechten. And so the civil courts, surprisingly, apply constitutional principles in hate speech cases, against Facebook, all these topics. Do you have a feeling that Brazilian courts are doing the same?
Yes, Professor Hoeren, we have in Brazil, in this sense, a really completely different approach than in Germany, because in Brazil, although having some resistance, of course, now it's really temperate, but we have really some abuses in this sense. We recognize the direct efficacy from fundamental rights in private sphere, in private relations. Of course, if this leads to some abuses, people, they really don't look to legislation and try to put into the decisions, into the case law, sometimes her own thoughts, interpreting the Constitution very broadly. So I think, of course, we have some abuse in this sense, but of course we have lacks of regulation, important lacks of regulation, in which we really need the Constitution to be applied. So I think a mix. And another difference is we have a diffuse. Each judge in each court is competent, is allowed by the Constitution to do the control of constitutionality. So and declare a norm for unconstitutional, and do not apply the norm in a concrete case. So we have a mixed system, as you know, but it's sometimes confusing, because we have both. We have a concentrated and abstract control, gaining importance in the last years, and the diffuse control. And of course, this is a way to facilitate courts, civil courts, to apply in daily the Constitution and the fundamental rights, even in civil law cases.
Well, can I ask you a private question? I've been to Stellenbosch, where you have taught, and the only question in Stellenbosch, which was very important for them, is how do we generate a feeling in the population for privacy data protection? So I want to ask you, does the normal citizen in Brazil see privacy and data protection as a major topic, or is it a typical German approach to protect as many data as possible?
That's a difficult question. I would say that in Brazil, but it's more, that is not, I really have no really, maybe really good or information about this. But what we can see is that privacy is only an issue in general when we have a problem with this, a personal problem. But in general, Brazil is one of the countries that I can say that is proved. We have data, we have information about this. It's one of the countries, if not the one, with the highest level of self-exposition from people, especially in social media, and of these several communication schemes like WhatsApp and others. We have really the highest, one of the highest code of self-exposition of daily usage in terms of hours of social media and WhatsApp. And of course, a tendency to expose photos, personal photos from the family. So really, I think we do not have, in general, of course, a consciousness in the population about the value of privacy and data protection, although the number of cases is growing because if the person, it's only the question if you have a problem with this, then you really, okay, now I need this right, I need this protection. But in general, we do not have this social feeling, I must say.
Let me ask a final question. Our moderator is gone, so I'm the one who I can ask final question and finish our discussion. My question would then be, is there any impact of the US government in pushing access to data? And is there a trend in population to be afraid about the things Snowden has said? Because Snowden seems to me to be very, very important and is much discussed in Germany. Is there such a big discussion as in Germany, in Brazil?
Okay, that's that's difficult. If you look at our legislation, our constitutional framework and our legislation and regulation, you of course we are close to Europe. We are close to Europe. But if you look at our economy, and if you look at what is really going on in practice, I think, especially in relation to hate speech, fake news, in these cases, the tendency, and by pressure of our media, is to be closer to US, I think. But in terms of data protection, of course, we have pressures coming from US, and our actual, of course, government was closer to US by Trump. Now they are not so really in good relations. They're not so friendly. But I think would say, in terms of our jurisprudence, of our legislation, we are not close to US, though having some pressures in this subject, but it's very new. So then our legislation is very new. And I think all these questions will become really relevant from now on. So it's relatively early to say something more conclusive about this. I hope having understood your point. So please apologize if I give the wrong answer for the question.
I wished I could close the session myself, and would like to thank you, Professor Hoeren, for his excellent speech, and Professor Sarlet for his excellent speech and explanations. but I'm afraid Angela is there again, and she
now.
has to say the final
She's
word.
here. She's here.
Thank you. I'm sorry, my internet connection was bad, and this is really sad, but I'm here now, and I'm sad that I lost your conversation. Hopefully everything was well, yeah?
Yeah, everything was well. So we can finish, and I would like to thank the audience, which I haven't seen, for listening to our talks, and it was very great to be here and talk to my really famous colleague, Ingo Sarlet. That was nice.
So I must thank you, Professor Hoeren, because I never thought I would have the opportunity to answer, or at least try to answer such questions, no? For you. And I apologize because I also could make some questions, but you make so many questions. No? So okay. I hope to have this opportunity later. Maybe you taking part in an activity from us at PUC, no? or even in Münster, if you allow, because we have also some connections with Münster. No? I know them, Fabian Wittek, he was with us, I think, 2 or 3 times in Porto Alegre. No? Professor Wolfgang, you're in English, have a lot in common with a colleague from us, he's tax lawyer. No? And so it would be a pleasure.
Here and waiting for you. They're all here and waiting for you to come, of course.
And it would be a pleasure to see you again in Brazil or in Münster. Thank you so much. Thank you, Angela. Thank you, Marcus.
Thank you. We need to finish now. I have some pair of questions here, but we will leave for next time. I hope I can make the questions personally to Professor Hoeren next year. So I'm very happy, and I'm sure the audience too. Thank you very much for both coming here today. Bye-bye.
Bye-bye.
Thank you, everyone. Thank you, Andrew. Thank you. Alles Gute, ne? Tschüss. Alles Gute.